Bob, I've just been named the executor of a will. Now what do I do?
Well, as the executor of the will, your job is to make sure that you have the original will. An original will means signed by the testator in ink, along with witnesses who are also signed in ink, that the document is stapled as it was when the testator or the person who made the will first did it years earlier. You should not take the staples out in an attempt to make nice copies of the will to send to everybody. You should leave the original staples in. Taking the staples out creates a whole set of other problems. And then what you should consider doing is retaining the services of an attorney who has some experience in the area of probating the will. Probating is a fancy word for submitting the will along with additional documents called a petition to the court for the court to determine, one, whether the will was validly executed, and two, whether all the people that should have received notices, those are primarily the closest blood relatives, that they've received notice that this will is in existence. Once the court is satisfied that that has occurred, the court will then name you in a document as the executor. You will take that paperwork and then go to the various banks and institutions and life insurance companies that the decedent may have had assets at and collect those assets. You would put that money into an estate account. You would also determine what the bills were for the estate: rent, mortgages, credit cards, things of that nature, taxes, and make sure those are all paid up. When you're also talking about taxes, you're also charged with determining whether or not there is an estate tax due on the whole estate. And you probably also want to engage the services of a CPA, to do that. So once you collect the assets, determined and paid all of the expenses and taxes, you will come down to a net figure. So what you would do at that point is you notify all the beneficiaries of the will that you collected X amount as a gross, minus that the expenses, and the net is such and such. Then you'd look at the will. The will would say how to divide the net. Many wills say a percentage: 25%, 25%, 25%, 25%. Some wills say 10,000, 25,000, 30,000, and then everything that's left over to somebody. You would present the beneficiaries with what's called an accounting. Hopefully, the beneficiaries agree with your math and what you did during the pendency of the estate. They would sign off. You would write them a check. You're also entitled to a commission, which your attorney would calculate. And once you have emptied the estate account, you are probably officially finished as the executor of the estate.